So I'm looking again at State of New South Wales versus Kiskanen preliminary, the New South Wales Supreme Court document 915 from 2021. Hearing date 21st July 2021. Date of orders and decision date 27 July 2021. Jurisdiction common law before Justice Julia Lonergan. Decision amended, summons dismissed. To plaintiff to pay the defendant's costs. So I'm going to be looking today at a summary of positions taken by the two parties regarding the statutory preconditions. And so this is Justice Julia Lonergan, in her own words, going through basically the position of the plaintiff. So it's worth noting that this is before we have even heard from the defence. And I thought, rather than looking at an article, we can look at a picture of Ua Kiskonen and remind ourselves that this is what happened to a man. A year of his life was taken from him, and he was forced into involuntary treatment in a clear breach of Rule 92 of international humanitarian law, at the very least. So, Article 49. The plaintiff argued that the requirements of Section 27A of the Act are met given the defendant's current sentence of imprisonment is due to expire on 29 July 2021. And the sentence of imprisonment was imposed for a New South Wales indictable offence, the firearms offences arising from the gel blaster gun found at his home. Article 50. The plaintiff submitted that the court would be satisfied that the requirements of Section 27B have been met because the matters alleged in the supporting documentation would, if proved, justify the making of an extended supervision order. It was emphasised that the court must take the allegations and documentation at its highest, and it is not for the court at this stage to weigh up documents or resolve any conflicts or inconsistencies which appear in the documentation, nor to predict the ultimate result or consider what evidence the defendant might present at final hearing. Article 51. The defendant is a, quote, convicted New South Wales terrorism activity offender, end quote, having regard to the definition of that term in subsection 10.1 and 10.1a of the Act, because he has previously made a statement advocating support for violent extremism, or has previously had personal or other affiliation with a person, group, or organisation that is or was advocating support for violent extremism, section 10.1c of the Act. Article 52. Having regard to the broad meaning of, quote, violent extremism, end quote, that captures conduct that might not satisfy the technical definition of a, quote, terrorism act, end quote, particular matters were identified, said to be evidenced in the documentation supporting the plaintiff's application, which would, if proved, amount to advocating support for violent extremism for the purposes of Section 10.1c of the Act. The defendant making statements to DSC Gatwood, including that, quote, breaking the rules could cost him his life, end quote, and the references to hanging, which are in effect threats of violence that are promoted by a person, group, or ideology that supports violent extremism, namely the UKOA. What was said in the email in July 2020 regarding, quote, holding to account under military jurisdiction, end quote, any police officer that, quote, tries to force themselves onto me, end quote, and, quote, I'm sure I don't have to point out that war crimes may be punishable by death, and the Nuremberg trials will tell you that following orders will not protect you from a rope around your neck, end quote, amongst other statements. The YouTube video on 27 July 2020 that included comments implying that certain police activity was treason, that the police are quote, a foreign military threatening peaceful civilians, end quote, and that the police should be exposed to the punishment of hanging. Article 53. It was submitted that the fact that the threats appeared to contemplate some form of court or tribunal proceeding first occurring before the punishment of hanging does not deprive the propositions expressed of their extremist character. Article 54. In terms of assessing whether there was an unacceptable risk of committing a serious terrorism offence, the plaintiff emphasised the facts giving rise to Commonwealth offences, which stemmed from the defendant's ideological connection with the UKOA movement. The ideology evidenced in his social media postings, as well as his poor mental health. It was argued that the material referred to in the Facebook post regarding the activities of UKOA and that movement's ideology comprised statements consistent with the use of a violent extremism to achieve their aims. This is in turn consistent with what the defendant says in his own Facebook and YouTube posts. Sorry, I just realized I've been referring to these as articles. It should be paragraphs. So paragraph 55. Although recent communications between the defendant and his Justice Health mental team appear to include disavowal of his previously expressed beliefs, recorded conversations between the defendant and UKOA members on 29 January and 18 February 2021 suggests that he still maintains those beliefs. Paragraph 56. And these are the Justice's own words here. 56. I interpolate here to observe that I am not persuaded that those phone calls form a solid basis for that submission. There are statements made in those calls by the defendant that suggest to the contrary, and the calls were almost 5 months ago. So this is before Justice Julia Lonergan has even heard from the defence. She's raising questions here about the plaintiff's positioning. 57. The plaintiff submitted that concerns regarding mental health comprise the nature of the defendant's mental illness, the poor history of compliance with medication, and his failure to comply with supervision by community corrections, as well as his lack of insight and impaired judgment. Paragraph 58. The written and oral submissions made on behalf of the plaintiff then descended into a level of complexity which it described as potential, quote, risk scenarios, end quote. The complexity of these potential and in some ways speculative scenarios, to my mind, underscore the speculative and uncertain nature of the risk allegedly presented by the defendant that he will commit a serious terrorism offence. 59. The first scenario was said to comprise the defendant continuing with the conduct of the kind engaged in prior to his arrest and incarceration, and the second, the risk of escalation of his conduct. It was explained that the first risk, 60. It was explained that the first risk was the defendant's previous threats of hanging authority figures, including police, as threats of action that would fall within the definition of, quote, terrorist act, end quote, in section 100.1(2) of the code, but not subsection 3. These are threats of an action that would result in death, and are threats made, first, with the intention of advancing a political or ideological cause, and second, with the intention of influencing the police or other public figures in the performance of their duties. It was argued that the defendant's, quote, continued adherence, end quote, to these previously expressed beliefs indicates a real prospect of him resuming conduct of the kind engaged in prior to his arrest, and so there is a significant likelihood of the defendant engaging in conduct that constitutes a terrorist act, being an offence contrary to Section 101.1 of the Code. 61. The plaintiff accepted that the threats of violence are stated to only occur following the regime change for which the defendant advocates, but argued that this still satisfies the definition of, quote, terrorist act, end quote. And while the likelihood of threatened hangings might be low, and while the defendant may have had no intention to encourage immediate acts of violence, such threats are significant because they might, quote, create a milieu which fosters the prospect that personal injury will be suffered by innocent members of the community, end quote. Paragraph 62. Alternatively, it was submitted that the defendant's conduct in publishing the videos on Facebook containing the material described above may lead to offences contrary to Section 101.5, collecting or making documents likely to facilitate a terrorist act, or Section 101.6, doing any act in preparation for planning a terrorist act under the Code, particularly as the defendant is only required to be, quote, reckless, end quote, as to the connection between his conduct and a terrorist act in order to establish those offences. 63. The plaintiff argued that the connection between the videos of the kind made by the defendant and the commission of a terrorist act is a real one, given that those videos identify persons said by the defendant to be a legitimate target for retributive violence. 64. Whilst there are disavowals of violence in the material, these disavowals occur alongside statements such as, quote, gotta start carrying out action to deal swiftly with the foreign administrators ruling over a country with no rule of law, end quote, and, quote, I have now given you enough evidence to crucify this man, end quote, and, quote, no one is truly prepared for what's coming, end quote. So before I go into 65, just a reminder again that these are the words of Justice Julia Lonergan, having heard only from the plaintiff's lawyer and not having heard from Matthew Johnston, the defendant's lawyer. 65. I interpolate here in regard to these statements that I do not see any of them as having sufficient clarity of proposed action to amount to a, quote, call to arms, end quote, for violence. I'm going to read that again, 65. I interpolate here in regard to these statements that I do not see any of them as having sufficient clarity of proposed action to amount to a, quote, call to arms, end quote, for violence. 66. Regarding the second risk scenario, the plaintiff submitted that the risk assessment report author has concluded that the defendant is, quote, vulnerable to acting or engaging in violence to achieve the goals of the UKOA. If the narrative shift was to shift towards the people of Australia, adopting rules within the kingdom that is creating perceived legitimacy for engaging in violence, warfare, policing, and or military jurisdiction, end quote. 67. The plaintiff submits that this risk is unacceptable, given that the defendant had previously made threats to police officers that may reasonably be interpreted as death threats. 68. His previous non-compliance with the CCO, which occurred back in May 2020, was premised upon his ideological beliefs. This is cited as evidence of risk, as is his reluctance to engage in mental health treatment. His criminal history involves some violence and some past difficulty with anger management, based on information provided by his de facto partner, and these two are said to be matters that heighten risk. 69. It was submitted that the court should place weight on the conclusion by the risk assessment report author that he is at moderate to high risk of engaging in politically motivated violence. 70. He was not compliant with his CCO. There is a risk that he may not comply with his CTO. His beliefs and commitments amount to a type of, quote, call to arms, end quote, to others with use of social media posts. He has some influence as a, quote, leader, end quote, of the UKOA movement. 71. In broad terms, in relation to the relevant Section 25 factors, before incarceration, his behaviours were escalating, as was his level of fixation and obsession with, quote, the cause, end quote. His delusional belief system regarding the legitimacy of the Australian government has real capacity for risk that he will either engage in activity or disseminate extremist ideology to radicalise and influence others. 72. It was submitted by Mr. Emmett that the court should not infer that the defendant's attitude or beliefs have changed or lessened due to effective treatment of his mental illness, as the position is equally consistent with the medication having no effect. But the defendant choosing to hide his beliefs so he can be released, particularly given his perception stated in his February 2021 phone call with Mr. Cook that the reason he was refused bail was his adherence to UKOA beliefs. And the last paragraph in this section, I note that there is no evidence that the defendant was receiving any mental health treatment or support at the time of the 2019 or 2020 offending. So I think one of the many concerning things here is that the plaintiff's lawyer, Mr. Emmett, is arguing that the defendant, his position is that the medication has had no effect and he's choosing to hide his beliefs, which leads me to the question of, well, what is the possible justification for this treatment in the first place if it's had no effect, or we're to disregard the effects that it's had, yet was still administered to him involuntarily. So it seems that the plaintiff's position here is they're trying to have their cake and eat it too. Just reading paragraph 72 again. It was submitted by Mr. Emmett that the court should not infer that the defendant's attitudes or beliefs have changed or lessened due to effective treatment of his mental illness, as the position is equally consistent with the medication having no effect, but the defendant choosing to hide his beliefs so he can be released. Particularly given his perception stated in his February 2021 phone call with Mr. Cook that the reason he was refused bail was his adherence to UKOA beliefs. And if we go back to 65, Justice Julia Lonergan, I interpolate here in regard to these statements that I do not see any of them as having sufficient clarity of proposed action to amount to a, quote, call to arms, end quote, for violence. So the plaintiff is arguing that the court needs to assess the danger posed by the defendant as though the treatment has had no effect. So why then the treatment? Why, in paragraph 73, I note there is no evidence that the defendant was receiving any mental health treatment or support at the time of the 2019 or 2020 offending. There seems to be no real evidence of mental health condition until Ulrich Koehner was incarcerated and put before the Mental Health Review Tribunal, or the Mental Health Review Team, 8 days after being incarcerated. So just going over again the concerns raised by the justice before even hearing from the defence. Paragraph 56. I interpolate here to reserve that I am not persuaded that those phone calls form a solid basis for that submission. There are statements made in those calls by the defendant that suggest to the contrary, and the calls were almost 5 months ago. Paragraph 58. The written and oral submissions made on behalf of the plaintiff then descended into a level of complexity which it described as potential, quote, risk scenarios, end quote. The complexity of these potential and in some ways speculative scenarios, to my mind, underscore the speculative and uncertain nature of the risk allegedly presented by the defendant that he will commit a serious terrorism offence. Remembering that the United Kingdom of Australia was never labelled as a terrorist organisation, and as we'll find out in the next part, the sentencing of the defendant in the first place didn't involve any offences under the Terrorism Act. So how can the plaintiff be relying on this perception, this threat of the Terrorism Act being carried out when at most the defendant is not involved with a terrorist organisation? There is no intelligence based on any terrorism concerns or offences. We only have a fixation from the Fixated Persons Unit of New South Wales. And we have a man who was incarcerated for having a toy gun and for making offensive videos, for failing to meet a parole condition for a previous charge that was over a neighbourhood dispute, has then been incarcerated for 12 months, subjected to all sorts of probing from a mental health team with after 12 months not coming to any solid diagnosis of the mental condition, yet enforcing treatment involuntarily for 12 months, and then stating that the court should consider that it is highly possible that the treatment has had no effect. I find this staggering. How many ways can you have it? And it's not surprising that the justice has put this on the record. So this is before you even hear from the defence that the case is completely unravelled.